Welcome once again to Lehto's Law. Here's Steve Lehto.
Josh sent me another great story out of the ABA Journal, and Deborah Cassens-Weiss wrote it, and it's a story about an attorney screwing up badly. So we'll talk about it because it's entertaining to us. A lawyer who allowed client to write appeals brief is sanctioned for incoherent document. This is crazy. A federal appeals court has ordered an Aurora, Illinois solo practitioner to pay attorney fees and double costs. So those are obviously punitive in nature, to his opponent for allowing his client to write and submit an incoherent appellate brief using his electronic signature. And let me catch you up to date on this. Nowadays, a lot of courts allow electronic filing. And if you do e-filing, you can't just sign your name like you do when you dip the quill pen into the inkwell and sign your John Hancock and then do the blotter thing on it and let it dry. This is actually a thing you do with credentials like passwords and stuff. And you go into the computer system and you file a document with an electronic signature on it. And you can only do this if you have the credentials to an attorney, and you're not supposed to be handing these out to strangers. So apparently this attorney told his client, go ahead, draft something, sign my name to it, and file it. The 7th U.S. Circuit Court of Appeals in Chicago sanctioned the lawyer on Monday, according to the National Law Journal and Law 360. In their order and opinion, the appeals court said the monstrosity of an appellate brief was incoherent, and the appeal itself was frivolous, utterly frivolous. So they filed an appellate brief, which apparently, if you read it, made no sense. And apparently, if you even tried to figure out what they're talking about, it was frivolous by its very nature. So there you go. The brief is 86 interminable pages, as the court called it, and is neither concise nor clear, the appeals court said. It is chock full of impenetrable arguments and unsupported assertions, and it is organized in ways that escape our understanding. The decision upheld dismissal of the discrimination suit filed by the attorney's client and ordered the attorney to show cause why he should not be sanctioned. And the show cause hearing is where the court puts you on notice, say, hey, look, we're thinking about doing something to you, probably punishing you. Come into court and explain to us why we shouldn't. So it's kind of like, hey, the ball's in your court, get in here. So at the show cause hearing, the attorney tried to explain himself, but we'll talk about that in a second. In a footnote, the court called the brief a typographical nightmare that uses 5 different fonts, various font sizes, including 3 different fonts in one sentence, and capitalizes words seemingly at random. It may come as a surprise to some people, but the courts actually have standards. And they actually say, if you're going to file a brief with us, here's what we recommend. And now, you can get away with doing some things that are slightly different, like how you italicize something maybe, or whether you underline something versus bold it or so on. But using 5 different fonts and various font sizes, including 3 different fonts in one sentence, probably not a good idea. The attorney told the court he didn't have time to write an appellate brief or to examine the lower court record, so he didn't recognize that this was a hopeless case. He also said he authorized his client to submit the brief under his name using his electronic filing credentials. So he's admitting right here he violated all the basic rules, including the rule that an attorney who signs a document certifies to the court that he's read it and it's well-based and well-founded in fact and law. So by putting his name on something like that or letting someone else put his name on something, he's admitting that he violated the most basic rule of what attorneys do. In his response to the order to show cause, the attorney said the plaintiff was a longtime friend and he agreed to appear at oral argument for her. She had filed a discrimination case against a company and the manager of its Illinois warehouse without a lawyer. So he wrote that these were all grave errors of judgment and I can only apologize to the court and I promise I'll never allow this to occur again. But how do you let it happen in the first place? Come on. I have suffered through the most embarrassing and stressful moments of my legal career and perhaps my life during the oral argument. And after the publication of the court's opinion, and my reputation has been tarnished to the highest level as a result of my actions that caused such a scathing opinion in this matter. He also said he has embarrassed the venerable profession of law and the bar to which I've enjoyed the privilege of being a member for over 32 years, during which time my competence has not been called into question. Previously. 32 years. So here's the deal. I've mentioned before, I'm an attorney in the state of Michigan. Been practicing law for 28 years. I would never give my login credentials to federal court to anybody. Not even another attorney. For fear this could happen. And the excuse that, well, it's a longtime friend, it's not even an attorney. It's just a person. And the person is going to draft an appellate brief. And I know there's people out there who say, Steve, the courts should not be closed to litigants who aren't attorneys. if someone wants to come into court pro se or pro per, depending on which one you want to use, and represent themselves, they should be allowed to do that. And the court should give them deference. And the courts will. I've seen courts bending over backwards, figuratively speaking, to let a non-lawyer litigant argue a case. I've seen it. It happens. But the problem here is that's not what happened. The non-attorney created this monstrosity, the court's terms, not mine. And then the attorney said, yeah, sign my name to it. I don't even need to read it. Just sign my name to it and file it with the court. That's a problem. That's a very serious problem. And the problem's not the clients. Okay? I've mentioned this before, and I don't want anyone to take this the wrong way, but I've had people, whether they're clients or not, ask me to do things I won't do. They'll say, Steve, I want you to make this argument. I want you to file this case. I want you to sue these people. I say, no, I can't do that. Can't do that. They go, why not? And I explain it to them. And they go, I still want you to do it. I just told you why I can't do it. I can't do it. Literally. I can't. It's not going to happen. I've had people say, I'll go find another attorney. I say, go right ahead. I'm not emotionally attached to your stupid idea. Okay, you want to find an attorney who'll file that? If you can find one, more power to you. I don't think you can do it. So I have a sneaky feeling that if this client of this attorney's had shown him the brief and said, here's what I'm going to file under your name, over your name, he would have looked at it and said, oh my gosh, you can't do that. I'll get in trouble for that. Now, what lapse in judgment he had to let it happen, I don't know. I don't want to speculate because there's a lot of things that could be. Crazy things, each crazier than the last. I don't know. But the point is that somehow that happened. So next time you're in a position where somebody says, hey, can I use your ID for something? Whether it's signing credentials for federal court or to, go to a store and buy something, or I don't know. There's situations in life where somebody goes, can I go in and pretend to be you? and you think to yourself, I know this person. What could go wrong? Well, they could file something using 5 different fonts, including 3 different fonts in the same sentence, and make you look like such an idiot that you get fined and sanctioned and embarrassed nationally. Because as this Court of Appeals wrote in their opinion, those opinions are only usually read by other attorneys, but it got picked up by the ABA Journal. Again, a journal normally only read by attorneys for the most part and people in the legal profession. But now it's being scoffed at by people on YouTube, such as myself. And again, I know many of you are saying, yeah, but Steve, it's not getting full worldwide attention out there. But trust me, this guy's mortified now. He's mortified now. But still, backing up to the very, very beginning, when somebody said, hey, I got my case filed, and it got thrown out of court. I'd like to file an appeal using your credentials and your name and say that you drafted it and that you verified it's a good appeal. Can I do that? Please give me your login credentials to federal court. The guy said yes to that. And that, of course, like I said, is a mistake so monumental. You go, how could that happen? I don't know. And the guy doesn't actually give much of an explanation other than to say that, this is a longtime friend of his and he's embarrassed. He's been practicing law for 32 years. And he says that he'll never allow it to happen again. But, it's the kind of thing where I've said before, like in the context of drunk driving, I said, I can kind of understand the first offense because somebody may have miscalculated as to how much they had to drink. I understand that. I can't understand that. But a first offense like this, I look at that and go, I don't see how that happened the first time. That's the crazy thing. How did this happen the first time? And again, who knows? So there you go. The attorney who let someone else draft a brief, sign his name to it, and submit it to federal court using his login credentials has been sanctioned for an incoherent document being filed with his name attached to it. So he's been fined and sanctioned, and he's promised it'll never happen again, and I certainly hope so. So there you go. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. But I digress.